Viewers, you're watching Crux of the Matter. After Delhi Chief Minister Arvind Kejriwal and BRS legislator Kavitha were denied bail by the courts, there has been much renewed scrutiny of the PMLA, or the Prevention of Money Laundering Act. The Congress party in its manifesto has even promised to defang the law so that its sharp teeth are blunted. The BJP says that the opposition is trying to water down the provisions of the PMLA to ring-fence themselves after committing acts of impropriety. There's no doubting that the law is stringent, but some of its most allegedly draconian provisions were introduced by the Congress party itself when it was in power during the UPA years. The PML bill, that is the Prevention of Money Laundering Bill, cleared both houses of Parliament by July 2002 when Vajpayee's NDA was in power. But it came into force only in 2005 after rules were framed by the UPA. The effect is that political parties at that time across political spectrum opposed, quote, draconian law, unquote, warning governments couldn't be trusted with its use. In fact, the common refrain amongst all political parties was that this law will entice governments to misuse it against its political opponents. However, viewers, in 2009, criminal conspiracy was added to the PMLA schedule. The effect was it allowed the ED to enter cases where a conspiracy is alleged, even if the principal offence is not part of the PMLA schedule. The effect in practice has been that the ED could take over an FIR in alleged land grabbing case against, for example, former Jharkhand Chief Minister Hemant Soren. In 2012, 3 years later, the PMLA was amended to move the Prevention of Corruption Act to Part A of the statute's schedule from Part B. What was the effect? The effect was that the amendment applied stringent bail conditions to those accused of corruption. In practice, the effect was to be felt by people like Chhagan Bhujbal, Manish Sisodia, Satyendra Jain, who were denied bail for long. In fact, Mr. Bhujbal was in jail for almost 2 years, and most crimes under the PMLA Act attract a maximum sentence of 3 years. So if someone has already served 2 years without being convicted in a case or in an alleged crime that carries a maximum sentence of 3 years, then quite clearly the process, it could be concluded, is worse than the punishment. Now, viewers, in 2021, the PMLA, of course, let me just give you a little bit more context. Its provisions have been challenged numerous times. And in 2021, the Supreme Court upholds the manner in which the provisions of the PMLA were invoked. The effect is that the legal sanctity for stringent bail provisions placing onus on the accused to prove innocence, wide police powers and retrospective application of law stay very much in place. And you can now see, of course, the effects of that as the ED, and this is a hard fact, viewers, is overwhelmingly proceeding against opposition leaders. Now, I want us to have a conversation with two lawyers to discuss whether the PMLA Act needs to be watered down, or is the opposition protesting a little too much? Let's begin. We have with us Sanjay Hegde, Senior Advocate of the Supreme Court, and we also have with us Nalin Kohli, Senior Advocate, to debate this issue. Mr. Hegde, granted that the money laundering law has come to have vast scope that grants the police powers to the ED, and it allows it to take coercive action against politicians and those accused of corruption, etc. And there's also this high bar for bail. And of course, amendments have been made by both UP and NDA that I've fleshed out on the screen, which has made the PMLA tougher over the years. But all of these provisions have been upheld by the Supreme Court in 2021. So why should we now go back and re-look at this law? The Congress is promising to do so, to water it down. Do we really need to? Or are we then defeating the purpose for which this law was framed?
Look, laws are framed depending on the situation. It is always open to any parliament or any legislature to take account of the changed situation and change the laws. The mere fact that it has been upheld as constitutional only means that the Supreme Court says that yes, you have the power to do it, you have done it, and it does not violate any of the fundamental rights the way we have interpreted the law. But notwithstanding all that, laws also get abused. Both TADA and POTA were upheld by the Supreme Court. Yet, thereafter, a subsequent parliament thought that it was capable of such great misuse that it should not remain on the statute books. The same thing is happening now with the PML. Like money laundering, our international obligations under PACT were to go after arms money and drugs money. Now, what India did when it expanded the PMLA was to put in every kind of crime as a predicate offense. Bribery, corruption was also there, but also ordinary things like robbery and all that. Now, it is one thing to get tough with hardcore drugs dealers, arms dealers, go after narco-terrorism. But if you use those same harsh laws on ordinary crime and then start using it selectively, we have case after case where people are in the crosshairs of the ED, then they seek sanctuary in one political party, and then mysteriously all those cases end up not going anywhere, or at least those people remain out of jail. Equally, people who are given offers to cross the fence,
right,
and have refused, have stayed on in their parent party, have seen jail, and then they've come on to win. I'm talking of somebody like Mr. D.K. Shivkumar in Karnataka. So there is now great many instances where it does appear that the ED acts mindful of political consequences.
No, that I understand. That we have established that the ED is selective, but does that mean that the law needs to be watered down? Perhaps there has to be accountability set at a different level. But why do we tinker with the PMLA?
That's why I give you the TADA and POTA example.
Okay.
Once you give any authority unlimited power, then that great saying comes in, that power is delightful.
Okay.
Unlimited
so
power
it will be abused?
Is absolutely delightful.
Okay, let me bring in Mr. Nalin Kohli. Mr. Kohli, do you think the opposition is protesting too much because now the shoe is on their foot? I have already recounted how in 2009 and 2012 the PMLA was amended to move the Prevention of Corruption Act 1988 to Part A of the statute schedule from Part B. Also, criminal conspiracy under Section 120B of the Indian Penal Code was added to the PMLA schedule among various other offences. This was all done by the opposition. Today, when the shoe is beginning to pinch, they want to water down this law. Is there a case for this, or are they trying to ring-fence themselves from, well, prosecution?
It's a statute, it's a law. And as you correctly pointed out, Rahul, it was brought in by the opposition parties themselves. The difference is they bought the law, but they perhaps chose not to use it. Now it's being used. That's the only difference. It's been upheld by the Supreme Court. But this seems to be a standard Congress pattern. They would bring a law, later on they will speak that this should be removed, this is not correct because it's being misused, but then the whole legal procedure is there. People are invoking their legal rights, and where there is merit in those legal rights, the courts are stepping in too. But just because the Enforcement Directorate, under the statute, which is duly upheld to be constitutionally valid, is taking action against those it believes are involved with slush money, that doesn't mean that you will throw the law out of the window because those people happen to be from the opposition parties. Let me give you 2 or 3 examples. The largest seizure of cash in the house of a member of parliament in the history of independent India is 351 crores that MPs from the Congress party. It's unimaginable, this kind of cash. 351 crores. Obviously, the law has to take its own course. The Trinamool Congress, which is also speaking a lot on the Enforcement Directorate, their leaders, 20 crores cash, 25 crores cash, 17 crores cash. That means somewhere the Enforcement Directorate is targeting the right people. Now, if they happen to be from the opposition parties, and that credible information is resulting in seizures and investigation, will you throw the law out of the window just because the opposition party says, no, don't target us? That can't be the basis. And I think the second part is, we must have faith in our courts. The very courts who on one day also announce judgments against the government are the ones who have upheld the law. And the same court, no less than the Supreme Court, also gives, where there is merit, a bail. Where there is no merit, continues with the incarceration of the person who's in jail under the same act.
Okay, let me bring in Mr. Hegre. Mr. Hegre, there are checks and balances. The courts, you yourself have mentioned D.K. Shivkumar's case, Chhagan Bhujbal's case, and of course Sanjay Singh's case. Well, if there isn't much, then the court steps in and says as much.
No. When does the court step in? The court stepped in even in Sanjay Singh after 6 months or more. Today, Sanjay Singh has spent 6 months in prison without a charge being proved against him. The very nature of this draconian law is that we will take you in first, then if the court lets you out through that rigmarole and that very tight maze, that is no proof. We do not necessarily have to take you to trial. The Enforcement Directorate has, on various occasions, sought to arrest people first and then figure out whether there's a case or not. Recently, the Supreme Court in Chhattisgarh said, how do you lodge a PMLA case when there is no predicate offense? The offense was under the Income Tax Act, which is not an underlying offense under the PMLA. So that is what I wish to tell your viewers. The PMLA is one set of offences, but it is based upon an underlying offence. The underlying offences should have been only with regard to drugs and arms dealing. That is what India's international treaty commitments were.
Okay.
Now, once you have expanded the scope for the PMLA to come in, for the ED to come in, then they are not bothered about prosecuting and proving even the basic offense, the predicate offense.
Well, some people...
Because in the meanwhile, they can arrest somebody and keep him in prison indefinitely.
Okay, with due apologies,
Indefinite detention without trial.
Okay,
that is the problem.
With due apologies, many ordinary Indians, sir, are languishing without trial in jail. We know this. So why should we create a holy category for politicians? Wouldn't that sort of mean that they have their cake and bake their cake and eat it too?
Well, I do agree with you. And I do think that courts should be much easier on granting bail.
Okay.
Today, the power of the policeman comes from the fact that he can accuse you of something, put you inside, and then you and your family have to run through a torturous system to get out.
Nalin Kohli,
now,
respond to this point. This is an important point, that liberty is taken away instantaneously at the behest of an officer of the law. And the onus is on...
Yes, with reasonable grounds to do so.
Okay, go ahead.
I think, Rahul, there are 2 points to be made here. With reasonable grounds to do so. And that same power exists also in the criminal manual under the CRPC, the Criminal Procedure Code, that in an emergent situation, that liberty can be taken away by a police officer. And therefore, that's how the criminal law is. I don't understand the argument that after all, if there is an undue exercise of power, there is an abuse of power, then one can go to the court, and people do go to the court. They go every day. And where there is a genuine case where it is established that there is abuse of power, misuse of power, the courts step in pretty strongly, if I may say. But that can't be based on one's desires. I mean, somebody from the opposition party says that this is abuse. They have to establish abuse. They have to establish misuse of that power. Has it been judicially done in the correct manner, as it is prescribed, as the procedure followed? Is there a reasonable ground, and it's not just a whitewash in terms of manufacturing a reasonable ground for arrest? Is there something credible in terms of the investigation? That may not be revealed to the public. That may not be revealed to the other side, because that's part of the trial process where the accused will have a right to see everything. But at the preliminary stage, the court often asks for those details, examines those details, and therefore, to put it as bluntly, some political leaders of the opposition parties, if they continue to be in jail, then perhaps the question to be asked is not, this is misuse of power and shouldn't this power go? The question to be asked is, what wrong did they do, that even the courts are seeing merit in continuing them to be in jail?
Well, viewers, it's always a fascinating conversation, isn't it, when two lawyers go up against each other, and two eminent ones such as these. I'm not going to weigh in with an opinion here. I'm going to leave it at this. It's been a great conversation. Thank you. Viewers, you're free to draw your conclusions. Well, we are now joined by Mahesh Jethmalani, Rajya Sabha Member of Parliament and Senior Advocate. Thank you very much for speaking to me today. Mr. Jethmalani, we have been looking at this entire opposition lament that the PMLA, its teeth are too short, too sharp rather, and they need to be sort of filed down to size. What do you make of this?
Well, you know, I don't think that that's a correct perspective at all. You know, money laundering is an extremely serious offense. Basically, money launderers are those who hide the trail of proceeds of crime. So, and it's an extremely difficult, you know, it is such a, it is so layered, the concealment of the proceeds of crime are layered in such a manner that is an extremely tedious task for any investigating agency to unravel it. It takes time, and it is a difficult task. So I think the criticism is unfair. And besides, you know, in Vijay Madan Lal Chaudhary's case, all these matters were discussed. There were 3-judge bench of the Supreme Court, right? They've gone through this entire argument threadbare. Every provision that could have been challenged was challenged. Wherever the provisions were, you know, stringent, they were challenged. And the court has spoken. There's also a review filed right now, and that review, you know, will get its just treatment by the court in due course. So I don't know why they keep. I think this is more political and optics. You know.
Well, let me tell you why. There is a worry. There is a worry that, for example, a section like 45(1) of the PMLA that requires the public prosecutor must be given an opportunity to oppose any application for release on bail sort of lengthens the period that you are denied bail, sometimes as much as 2 years, for example. PMLA offenses usually maximum time in jail 3 years, for instance, and you sort of the process, as they say, is worse than the punishment. Now, there are laws, of course, that have draconian provisions and have been upheld. But then we have realized that in the wrong hands, they are open to misuse. Is this a case of that happening? The opposition says very selective the application of the ED. They are only going after opposition leaders, and there is some merit in that. Let's not blindly disregard that point of view.
Well, you know, if I agree. I mean, there could well be. I mean, there could well be, and let's be objective. I'm sure that there are cases which have gone a begging, right? But then it behoves the opposition to spell these out bring the matter to court. You can't keep just, ad nauseum repeating this on television channels and in the media. You can't keep doing that, right? There is a way of rectifying this. I often feel that the prosecution is not serious about corruption, and they just use it as an anti-government mantra. They use the misuse as an anti-government mantra, because they should then put their mouth where put their money where their mouth is, their effort where their mouth is. They should then be going to court, take some effort, bring out the evidence, and say, look, this is the reason why we are saying there are double standards. Until that happens, I'm afraid I will consider it only a case of lip service. It is true. I'm not saying that it's not true that people who are facing prosecution, right, or investigation have joined the BJP. It is true. All right. You can't deny that. But there is no case where I've seen that a case has been closed against somebody, is not being pursued actively. And even if there is one which I don't know about, right, and I don't claim to be all knowing, right, then you go to court and say, why are you not pursuing this investigation? The court is the redressal mechanism for any such grievance you have.
Now, let's just come back to the point that I actually made. Forget about the selectivity for a few moments. Let's park that aside, because that really doesn't flow really from the PMLA as such. The consequences that flow from the PMLA are the reversal of the onus of proving your guilt, really, which lies on the accused. And you know that the ambit of the PMLA has been, of course, widened so that the ED can get into all sorts of cases, and not just, of course, money laundering that was what the original brief was, etc., etc. And we've seen that. So do you believe that perhaps there is a case to review this? Because it is going a little too far, according to some people.
Well, let me tell you, there are two provisions which are really controversial. One is the bail provision, which you referred to, 45(1). Now, in principle, I'm in agreement with the critics. I'll tell you why. Right? Because bail should never be a matter, right, of having to prove your innocence at that stage, or a prima facie innocence. Right? That should never be. Bail is something which you get once your case is established, investigation is over, and then unless you're a flight risk, that's in most countries which follow Anglo-American jurisprudence, that's what happens. If you're not a flight, or if you're a very powerful person who's prone to as a history, or you're a repeat offender. There are well-known categories when bail should be refused during trial, or it's a very serious offense like a terrorist, right, or a big-time narcotic dealer, not an ordinary user. Right? Now, these are the categories of cases where it should be done. Now, money laundering, it's punishable only with 7 years. Right? So you're right. Practice has shown that most of the people who have spent time in jail without the denial of bail, right, has been inordinate compared to the maximum period. That has been inordinate. Now, why that has happened is sometimes because there are some cases where the offenders have been serial offenders, Rahul, in the sense that they have committed a number of offenses. So it seems like this is all in one case. But actually, the principal offenders, I don't want to take names, some of whom I've appeared, right, have actually been involved in a series of cases, and the total length of period spans all those cases. The total length under which they've been in detention spans all those periods. I'm not saying that there aren't cases where there has been inordinate delay in a single case on granting bail. But sometimes quantum and detection of an offense, evasive answers, getting to the truth, etc. And why money laundering has become such a big issue with investigating agencies and this government in particular is because people have indulged in daylight robbery. This is a case where small-time investors, poor people, middle-class people, right, through decimating banks, and also a very deleterious effect on the economy. So, and it takes time. The investigating agencies are, doing a great job. Let me tell you, right? They were completely undermanned and overworked. Right? So that's probably one of the reasons. You've got to sort that out, right? A fair system of justice requires more personnel, right? and also requires more courts to deal with bail.
Okay, so you believe that we do not require to in any way amend any of these provisions. In fact, the problem stems from the fact that the opposition, which of course put in some of those provisions, emasculated the agencies because they didn't really use them to do what they were supposed to be doing. And today the government has come in that is actually empowering the ED, the CBI or the other agencies to do what they're supposed to be doing, and therefore don't whine about it. Do I get this right from you?
Yes, I mean, certainly it doesn't lie in the mouth of the opposition to complain about this, because for 10 years, look, most of the cases which this government is investigating are really legacy issues, right? They're all legacy issues from the past. There has been what's been called evergreening. Evergreening of loans is just continued and it's been suppressed. There's been no proper audit done, and sometimes, in some cases, right, ministers have been responsible for this evergreening by making simple calls to the bank and saying, evergreen the loan, right? And then these loans are covered by the end of the financial year as having been paid back, and then post the financial year, the liability again emerges. So, these are all accounting tricks. Problem is also, Rahul, now auditors, there's so many auditors, right, of all these banks, etc., non-banking financial companies who have colluded with the principal, with the bank officers in charge, and also with these big-time offenders in terms of quantum. Right? So they've all colluded. So that is, what has happened in the UPA 10 years is the checks and balances, and therefore the integrity of the entire banking system and the non-banking financial system, and then Ponzi schemes where you cheat poor investors, right? These have mushroomed and proliferated. I can tell you one thing, Rahul. In my experience, in many of these Ponzi schemes, politicians are behind the scenes.
Okay, let me ask you a final question before I leave it to this. The Congress in its manifesto has said, and I quote it, that if voted to power, it will, quote, put an end to the weaponization of laws, arbitrary searches, seizures and attachments, binary searches, seizures and attachments, arbitrary and indiscriminate arrests, unquote, and promised to, quote, enact a law on bail that will incorporate the principle that bail is the rule and jail is the exception, unquote, in all criminal laws. What do you make of this?
Well, I think there are stringent provisions, right? As far as the law is concerned, there are some stringent provisions which need to be read down, right? I don't think any system of justice should have such stringent provisions of bail and should reverse the burden of proof. But so far as the PMLA is concerned, and that's the thrust of the attack, right? So far as the PMLA is concerned, the reversal of the burden of proof is once somebody is found with proceeds of crime, then the onus is on him to prove these are not proceeds of crime. There's a limited reversal of proof, and that's at the trial stage. On bail, the conditions are very stringent. They are very stringent, and the problem is actually it's all verbiage, right? Any court can sniff or should be able to sniff a case which is deserving of bail and a case is not deserving of bail, right? I mean, courts have become a little lazy, with all due respect, because they have what's called the twin conditions, right? So, now it's like, Mr. So-and-so, who's a defense lawyer, the court will tell him, you have the difficulty of the twin conditions against you. But, you strip the twin condition and get into the facts, you can still get bail in a good case.
Okay.
Judges ought to be able, good trained judges ought to be able to sniff out cases where bail is deserving.
And certainly there are good trained judges in the Supreme Court and in the High Court, where some of these matters do end up disadvantaging those that are seeking relief. Viewers, I leave it at that. Mahesh Jethmalani always is erudite and to the point. Thank you very much for speaking to me.
Thank you, Rahul. Thank you.
We'll take a very short break, viewers. We're looking at another side of this coin when we return.